That's why, I mean, basically, it's a little bit easier. We'll do it to the first quarter. Make this.
Okay, I just emailed the court reporter when she's not present, so I don't want to get started until she comes back.
It doesn't really help you working. You're going to be showing that sorry. But I'll look at the upper floor and I'll verify on the basement floor what's going to happen. And then stuff over to Jeff.
There she is. Can you hear me okay?
Hang on. Can you hear me, Cassandra?
Yes, we're
Okay.
going back on the record now.
Okay, I sent you an email.
I responded.
Thank you.
Okay, we're good to go.
We have a motion to reconvene.
I'll make a motion to reconvene.
I'll second.
All in favor?
Aye.
Aye.
Back in session.
Madam Chair, this is Fritz Shadley. May I give a further response to Mr. Blocker's inquiry to me before you rule, please?
Yes, go ahead.
This is in this case, OTR is making the argument that there are only 3 specific legal issues this board should evaluate. But the reality is, if you look at their reports and their exhibits, independent of the numbers in the exhibits, they admit the bell tower is dangerous. Because they say, in Mr. Klingler's email, which is one of their exhibits, exhibit number 16, they say that repairing it is urgent. It's in his email. You, the board, you cannot assess whether it can be repaired. Given the fact that they admit the building is dangerous, you cannot assess whether it can be repaired unless you listen to the numbers. So given what they've admitted, you have to listen to the numbers. Otherwise, if we're not going to listen to the numbers, then we don't need to have a hearing because they admit the building's dangerous. Your mission here is not to decide whether it can be repaired. That is not the burden here. That is not the legal issue. Your issue is it dangerous and is it imminently dangerous? They've admitted it is, but they've proffered what they think will be a repair. That's not relevant here.
So thank you very much.
I think Ms.
Are we
Chair,
re-arguing this motion?
we should, I think we do need to give Mr. Suter an opportunity to respond to that since we reopened it. Mr.
Sorry.
Suter, do you have any response to Mr. Shadley's additional arguments?
Yes, thank you. The question here is whether there's a serious danger, an urgent threat, and it's immediately necessary to demolish the building. Those are factual questions around technical issues. Mr. Shadley has admitted that it can be fixed. He just said that. With enough money, it can be fixed. We're talking about whether this can be stabilized. And that's really what the issue is here. Because if it can be stabilized, then it's not necessary to tear it down. And the order must be reversed. So the amount of money has nothing to do with it. And as Mr. Shadley said, anything can be fixed with enough money. So their whole argument is there's not enough money to fix this. There's a fix available, but there's not enough money. That's not an issue.
So after hearing all the arguments about that motion,
Sorry, excuse me, Chair. I had said something and I apologize here. I know I'm interrupting you, but I asked to respond to Mr. Suter no more than a couple sentences.
I'm sorry, you're asking to respond? You're muted, sir.
And unmute. How's that? Can you hear me?
Yes, so I think
Apologize.
we've actually discussed the issues. And I'm afraid that if we continue to go back and forth here, that we won't get on to the rest of the meat of the subject. And I feel like what we're hearing here is not changing the deliberations that we've had on this specific motion. And we'd kind of like to get to the rest of the topic. Is that
So-
okay if I go ahead and rule on the
Yes.
motion?
Yeah, so Madam Chair, you now, it's within your discretion to either grant this motion from the appellant or to deny the motion.
Okay, we've determined that we deny the motion. And I would just like to give a couple sentences on that. I think it's too early to determine what role the financial aspect of this plays in the whole discussion. But we would like to ask everybody here to prioritize the issues of the safety and the threat of imminent danger. These are the things we have to parcel through first. And then the discussion of the financial implications is secondary to that. And with that, I think we would like to get back on track with our normal order of presentation.
That's right. We'll begin with the presentation by the appellant, any
Madam-
arguments and witnesses.
Excuse me, Madam Chair, may I bring a motion and given the motion of OTR adopt, please?
Yes. Yes,
I think this is important to the entire hearing. Here's Mr. Klingler's email, an exhibit they've marked. The two engineers whose reports are strikingly similar on the above points, here it is, agree that the aforementioned repairs are most urgent. Are most urgent. The question before you, as raised in the motion that Mr. Suter argued on behalf of the appellant, the question before you is it dangerous? Is it imminently dangerous? Mr. Klingler says they are most urgent. It is imminently dangerous. I don't think you have an issue to decide. The question before you is not, can it be fixed? That's not the legal question. That's not anywhere in the rules or anywhere in the description of the issues to be decided by you. It's nowhere in, if you look at Mr. Suter's motion, it says the three issues are, 1 minute, please. The three issues are whether it's a, hang on, I got to find it in his. Oh yeah, here it is. Whether there's a serious danger, whether there's an urgent risk to public safety, and whether demolition is immediately necessary. They admit there's a serious risk.
I'm sorry to interrupt, Mr. Shadley. We have our court reporter has dropped off. We'll need to get her back online so that this can be recorded. I apologize for the
Oh, it's okay,
inconvenience.
I understand. Sorry.
Sandra, I assume she's going to pop back on. Can we reach out to her?
Yeah, I already did. She's getting back on.
Okay.
It should be just a minute. Just to update you, she's having some connectivity issues. She needs a couple of extra minutes, but she said she's working on it. I apologize.
What is her name, Cassandra? You know,
I think it's Cindy. Can you hear me, Cindy?
and Cindy, can you let us know when you're ready to go?
It's Brenda, sorry.
Sorry,
Cindy's
my
my
bad.
office manager. No, it's fine. It's no worries.
Are you ready?
My deepest apologies. I fixed the problem. It was a connection and it's now fixed. So I'm sorry.
Thank you. We're still in session.
Go
Mr.
ahead.
Shadley, you can proceed.
Thank you. I'll be as brief as possible. The appellant here has agreed that there are 3 issues for your determination. Whether there's serious danger, whether there's an urgent threat to public safety, and does that make the demolition immediately necessary? That's in his letter, which is his motion, which you have. Mr. Klingler has said this in his email, and I take this as an admission of the appellant. I'll read you 2 sentences. Art Dahlberg has concluded the tower presents an immediate risk to the public. The key question is, what conditions need to be remediated in order to abate that risk and remove that emergency order? How you solve the problem, how you abate the risk is not one of the 3 things that you're empowered to decide. You are empowered to decide, is it a serious danger? They've admitted it is. You're empowered to decide whether it's an urgent threat to public safety. They've admitted it is. You're empowered to decide whether demolition is necessary. But you are not empowered to decide, have they put forward a way to fix the problem? As he says, the key question is, what conditions need to be remediated in order to abate the risk? That is not this board's mission, how to abate the risk. This board's mission is, was Mr. Dahlberg right that there's an immediate harm risk that desires immediate action? Not to consider what the appellant plans on doing here, and that is putting forward different varieties of ways to fix this problem. That's not your issue. None of that evidence, my motion is to exclude all of that evidence because that's irrelevant to what you have to determine. You have to determine, do we have an immediate risk that needs to be solved, not how to solve it.
Madam Chair, may the City of Cincinnati respond to this motion?
And Mr. Shadley, are you through?
Yes, I am. Thank you.
Presenting? Okay.
Yes, please.
Thank you. I would posit that in fact, the issue is quite more narrow than either attorney Suter or Shadley are presenting. What has been appealed is a determination by the City of Cincinnati that in order to abate a hazard at the bell tower, that hazard is not being challenged. The condition of the bell tower is not challenged. What is being challenged is the city's authority to issue an order under the Cincinnati Municipal Code that allows for the abatement through partial demolition of a structure at 1212 Ray Street. And I hope that is helpful to the board as it deliberates today.
I'm sorry, I didn't hear your last sentence.
Oh, I just hoped that narrowing that issue was helpful as we hear from the parties through the hearing.
Yes, thank you. David?
Madam Chair, I think we should allow the appellant to respond to Mr. Shadley's motion.
Okay.
Thank you. In response to that, it's important to know the context of why we're here. This building at 1212 Race Street and the bell tower at 1208 Race Street are both located in the Over the Rhine Historic District. The Over the Rhine Historic District does not allow for demolition of contributing historic buildings, except in the event, and there are a couple exceptions, but the one that's at play here is in 143509-5C. It provides an exception to a COA, Certificate of Appropriateness. Quote, when the chief building official, Mr. Dahlberg, and the fire chief certify in writing that demolition is required for the immediate preservation of public safety because of an unsafe or dangerous condition that constitutes an emergency. And further in chapter 1101, which is the Cincinnati Building Code, section 1101.63.4 allows the director and the city manager to, quote, abate dangerous and unsafe conditions that pose an immediate danger to the public health and safety. Read together, the question is, the key question here is demolition required? That is the main question. And there are three issues: whether a serious danger exists, an urgent threat to public safety exists, and whether demolition is immediately necessary. So is demolition required? We argue and have evidence that we'd like to present to this board that it's not. And therefore, there are other ways to do it. Mr. Shadley even said in his statements earlier that anything can be fixed with enough money. So it comes down again to the church not wanting to spend the money. There are fixes possible. We've got evidence of that. We also have evidence, by the way, that there's plenty of money to do it if the church would simply accept it. And we'll talk about that later. But the issue is whether demolition is required. We do not believe it is. There are other alternatives to demolition that we are asking you to consider. Thank you.
Madam Chair, for the city, may I offer just a brief response to that? I just want to be very clear that the order that is being appealed today does not require the property owner to expend funds. At this point, what the city is doing is exercising its nuisance abatement authority. So the question is whether it is reasonable for the city to repair the property, and it has been determined as required by 143509-5C that it is not. And I would beg that the board review the plain language of the code, because the three-part test that both attorneys for the appellant and appellee are referring does not exist in that code.
Thank you.
Can I ask a question?
Yes.
I'm not really sure what we should be doing process-wise here. So, but
Process-wise, Luke, the motion is now on the table. You can ask
Right.
questions and then address the motion.
so the first question is, can you remind me? There's been a lot of back and forth. What is the motion? It's a motion. It's like what exactly? Because there were a lot of
I was
things
going to ask the
discussed.
same question.
I just want to be very clear. Like, what's the motion asking us to do?
My motion is, this is Fritz Shadley on behalf of the appellee. My motion is to bar the appellant from putting into evidence how it is they propose to fix the imminent danger, the method of fixing. Because that's not relevant how to fix. The only relevant issue is it imminently dangerous? And they admit it is. So why are we here?
Okay, thank you. And to Ms. Fauborg's comment, and pardon me while I read through laws on the fly here, but the Mr. Souter's equivalency letter, I believe, to your point, Ms. Fauborg, the way I understood it, it lays out a three-part test, but that three-part test is a combination of two different parts of the code. That it's sort of like joining two parts of the code to say this is the overall standard that yields from these two different parts of the building code.
Madam Chair, to the board member, yes, my interpretation of this is that this is Attorney Souter's synthesis of the governing law. That said, it is not the city's synthesis, and we would not adopt this three-part test.
And so would you, for our benefit, repeat the city's view of what standard we are, is what is the appropriate standard for review here? Or not the way to put it. What is the section of the code from your perspective, we should be, applying?
Madam Chair, to the board member, the standard is the plain language set forth in code section 1435-09-5C, which identifies that where there is a need for demolition because it is necessary for the immediate preservation of public safety due to an unsafe or dangerous condition, there are steps that the chief building official and the fire chief must take in order to make that determination on behalf of the city so that the city may undertake nuisance abatement activity.
Mr. Chairman, Ms. Chairman, Madam Chair, sorry. Mr. Sturkey, can we just read the section of the code? Because I believe the attorney for the city just paraphrased. I think I had read the exact language and maybe it would be instructive to put it up on the screen or just read it. So because it uses words that demolition is required. It doesn't say, would be a good idea or is in their discretion. It's required.
It's within the discretion of the chair whether to allow that.
If you have it, I was trying to get it in front of me as well. And I think she was citing from the Cincinnati Municipal Code, right? Not the OBC.
That's correct.
Are we able to pull that up or does somebody have it that wants to share it? Or what would?
I think Sean is asking permission to read it into the record verbatim. Is that right, Sean?
I have a copy of it if you want me to read it. I'm sorry, I cannot share it.
That is correct. I mean, we can try to pull it up if you want us to. It's online. It's 1435-09-5 of the Cincinnati Municipal Code. And it's 1435-09-5C as in Charlie. And this is titled Exceptions from the Requirement to Obtain Certificate of Appropriateness. And I'm happy to read it in if you'd like, otherwise just take
That
note.
would be fine if you would like to do that.
Okay. So section 1435-09-5 titled Exceptions from Requirement to Obtain Certificate of Appropriateness reads as follows. Nothing in this chapter is to be construed to prevent or regulate, goes, and I'll just jump down to C if that's okay. And that's the relevant provision. Emergency demolition when the chief building official and the fire chief certify in writing that demolition is required for the immediate preservation of public safety because of an unsafe or dangerous condition that constitutes an emergency. Such determination shall be made in accordance with Cincinnati Municipal Code, Chapter 1101. That's the relevant provision. It goes on from there. I can read the rest if you'd like.
I don't think that's necessary. I think we have to deliberate on the motion if there are no more comments or.
Yeah, this is for Chaley. May I offer comment?
Yes.
I think I understand what the city's attorney said, and that is what's at issue. And if I'm mistaken, I apologize. I'm not trying to misconstrue it. I think what I heard the city's attorney said, what's at issue for this board, and I ask please the city's lawyer to correct me if I'm wrong. I'm serious. What I think she said was your duty, the board's duty, is whether Art Dahlberg acted in a way consistent with the language that Mr. Suter just read. In other words, did he and the fire chief certify in writing that demolition is required for the immediate preservation of public safety because of an unsafe or dangerous condition that constitutes an emergency? If I understood the city correctly, that's exactly what's in the order. He has fulfilled that in the order that's now before you that's being appealed. So if I've defined or understood correctly what the city's position is, the order itself fulfills that. All you have to do is read the order, read what's required by 1435-9-5. Once you read the order, you will, and you marry up the order to the statute, and perhaps what would be simplest for the board is to do exactly that. Put a copy of the order in front of you, put a copy of this portion of the statute in front of you, and you will see unequivocally that Art Dahlberg has in fact made each and every one of the findings that 143509(5) requires him to make. He has fulfilled the letter of the law. And if that's what the city says is the matter under appeal, we can solve this by your looking at the order and looking at the law, because he did it.
I'll just do a, I'm gonna do a procedural, Sean, if you could give me a minute, I'm gonna do a procedural check-in here. We have a motion on the floor here from the church and Mr. Shadley to bar the appellant from introducing evidence about how they would fix or how they could fix the bell tower. We are now at the point where the board can ask additional questions or entertain additional arguments on that motion. The chair can make a decision on that motion, or the board can make a motion to deliberate on the motion in private. How would you all like to proceed?
I'd like to make a motion that we begin deliberations in private.
May I respond to Mr. Shadley?
It is the discretion of the chair how many more arguments she would like to entertain on this motion.
Well, Mr. Suter, my question is it a response to something Mr. Shadley just said, which is outside of the motion? Because if it's that, I'd prefer that we wait till till we get back to the rest of the discussion and we clear out this motion first.
I just wanted to say that the issue of whether Mr. Dahlberg issued the order is not at issue. We can all agree that he issued the order. Thank you.
All right. Yeah.
I'll restate. I'd like to make a motion that we do deliberations in
Well, that would be my
private.
Just cut it down to
Second.
All in favor?
Aye.
Aye.
Mr. Locher,
Aye.
motion passes.